There we go. Good morning. Thank you for being here. Sorry, it was a little crazy down there, so we had to go to a different room and had you come up. Just want to make sure this is working. Do you hear it okay? All right. I hope you had a good weekend. We're ready to start today. We'll start here with final instructions, which is what you have in your seat there. We kill a small forest to make these things every time we do it. So they're there. You will have copies, just so you know. I want you to leave them when you leave, and we'll send back copies. We'll give you a number of copies so you have them in the jury room. So I will do these instructions, and then we will have the closings. And then once the closings happen, there's one little part of the jury instructions I'll finish up explaining what your charge is at that point. We swear the bailiffs, and then we have you go on in. One thing that happens right before that is we randomly take two numbers, and you're randomly given numbers, and those two people will be the alternates. I will say, if you want to leave right away, you're welcome to. Those who would like to talk to me a little bit, you can stick around after it takes a little time to sort of get to the very last, but you're welcome to wait in my office, and I'll talk to you then. I don't know who it is, by the way. Nobody knows because it's random. So, okay, having said all that, I think we're all ready to begin here. Now, members of the jury, the court will now instruct you on the principles of law that you are to follow in considering the evidence in reaching your verdict. It is your duty to follow these instructions. Regardless of any opinion you may have about the law, is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which have been properly proven by evidence. Consider only the evidence received during this trial, and the law is given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Nya Thao is guilty or not guilty, disregard that impression entirely. Decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Party to a crime. Section 939.05 of the Criminal Code of Wisconsin provides that whomever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although the person did not directly commit it. Three ways which Nya Thao can be a party to a crime. The state contends that Nya Thao was concerned in the commission of three crimes in the information in one of the following three ways. One, by directly committing it. Two, by intentionally aiding and abetting the person who directly committed it. Or three, by being a person of a conspiracy to commit the crime. If a person intentionally aids and abets the commission of a specific crime, then that person is guilty of that crime, as well as the person who directly committed it. And if a person is a member of a conspiracy to commit a specific crime, and that crime is committed by any member of the conspiracy, then the person and all members of the conspiracy are guilty of the crime. Definition of aiding and abetting. A person intentionally aids and abets the commission of a specific crime when, acting with knowledge or belief that another person is committing or intends to commit the crime charged, he knowingly either assisted the person who commits the crime or is ready and willing to assist the person who commits the crime, knows of the willingness to assist. To intentionally aid and abet first-degree intentional homicide, Nya Thao must have known that another person is committing or intends to commit the crime of first-degree intentional and have the purpose to assist the commission of that crime. However, a person does not aid and abet if he is only a bystander or spectator. It does nothing to assist the commission of the crime charged. Definition of being a member of a conspiracy. A person is a member of a conspiracy if, with intent that specific crime be committed, the person agrees with or joins with another for the purpose of committing that crime. A conspiracy is a mutual understanding to accomplish some common criminal objective or to work together for a common criminal purpose. It is not necessary that conspirators had any express or formal agreement, or that they had a meeting, or even that they knew each other. If a person is a member of a conspiracy to commit a specific crime, and that the crime is committed by any member of the conspiracy, then the person and all members of the conspiracy are guilty of the crime. State's burden of proof, party to a crime. Before you may find Nya Thao guilty, the state must prove by evidence which satisfies you beyond a reasonable doubt that Nya Thao directly committed the crime of first-degree intentional homicide, intentionally aided and abetted the commission of that crime, or was a member of a conspiracy to commit that crime. Unanimous agreement not required regarding theory of party to a crime. All 12 jurors do not have to agree whether Nya Thao directly committed, intentionally aided and abetted, or was a member of a conspiracy to commit the crime. However, each juror must be convinced beyond a reasonable doubt that Nya Thao was concerned in the commission of the crime in one of those three ways. Counts 1, 2, and 3, first-degree intentional homicide as a party to a crime. Statutory definition of the crime. First-degree intentional homicide is defined in 940.01 of the Criminal Code of Wisconsin is committed by one who causes the death of another human being with the intent to kill that person or another. State's burden of proof. Before you may find Nya Thao guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt the following two elements were present. For count 1, the elements of the crime that the state must prove: 1, that Nya Thao directly or as a party to a crime with Kempthanath Ratanasak caused the death of Nemo Yang. Cause means an act of shooting with a substantial factor in producing the death. Nya Thao directly or as a party to a crime with Kempthanath Ratanasak acted with the intent to kill Nemo Yang. Intent to kill means that Nemo Yang had the mental purpose to take the life of another human being. Excuse me. Let me try again. Intent to kill means that Nya Thao had the mental purpose to take the life of another human being, or was aware that the conduct was practically certain to cause the death of another human being. For count 2, the elements of the crime that the state must prove: 1, Nya Thao directly or as a party to a crime with Kempthanath Ratanasak caused the death of Peng Lor. Cause means the act of shooting with a substantial factor in producing the death. 2, Nya Thao directly or as a party to a crime with Kempthanath Ratanasak acted with intent to kill Peng Lor. Intent to kill means that Nya Thao had the mental purpose of taking the life of another human being and was aware that his conduct was practically certain to cause the death of another human being. For count 3, the elements of the crime that must be proved: count 1, that Nya Thao directly or as a party to a crime with Kempthanath Ratanasak caused the death of Trevor Maloney. Cause means the act of shooting with a substantial factor in producing the death. 2, Nya Thao directly or as a party to a crime with Kempthanath Ratanasak acted with intent to kill Trevor Maloney. Intent to kill means that Nya Thao had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that Nya Thao acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Nya Thao's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent and motive. Intent must not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of Nya Thao, the state is not required to prove motive as part of Nya Thao in order to convict. Evidence of motive does not by itself establish guilt. You must give it the weight you believe it deserves under all circumstances. Jury's decision. For count one, if you're satisfied beyond a reasonable doubt that Nya Thao directly committed all two elements of first-degree intentional homicide of Nemo Yang, or that Nya Thao intentionally aided and abetted the commission of the crime, or that Nya Thao was a member of a conspiracy to commit the crime, and that the crime was committed by a member of that conspiracy, you should find Nya Thao guilty. If you're not so satisfied, you must find Nya Thao not guilty. For count two, if you're satisfied beyond a reasonable doubt that Nya Thao directly committed all two elements of first-degree intentional homicide of Peng Lor, or that Nya Thao intentionally aided and abetted the commission of that crime, or that Nya Thao was a member of the conspiracy to commit the crime and the crime was committed by a member of the conspiracy, you should find Nya Thao guilty. If you're not so satisfied, you must find Nya Thao not guilty. For count three, if you're satisfied beyond a reasonable doubt that Nya Thao directly committed all two elements of first-degree intentional homicide of Trevor Maloney, or that Nya Thao intentionally aided and abetted the commission of that crime, or that Nya Thao was a member of a conspiracy to commit the crime and that the crime was committed by a member of the conspiracy, you should find Nya Thao guilty. If you're not so satisfied, you must find Nya Thao not guilty. Count four, possession of a firearm by a prohibited person. Statutory definition of the crime. Section 941.29, parent 1M of the Criminal Code of Wisconsin is violated by a person who possesses a firearm if that person has been a prohibited person of possessing a firearm. State's burden of proof. Before you may find Nya Thao guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt the following two elements were present. Elements of the crime that the state must prove. One, Nya Thao possessed a firearm. Firearm means a weapon which acts upon the force of gunpowder. Possesses mean that Nya Thao knowingly and had actual physical control of the firearm. Two, Nya Thao had been a person prohibited from possessing a firearm before Friday, July 23, 2021. The parties have agreed that Nya Thao was a person prohibited of possessing a firearm before Friday, July 23, 2021. Deciding about knowledge. You cannot look into a person's mind to find knowledge. Knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. An item is in a person's possession if it is in an area in which the person has control and the person intends to exercise control over the item. It is not required that a person own an item in order to possess it. What is required is the person exercise control over the item. Jury's decision. If you're satisfied beyond a reasonable doubt that both elements of the offense have been proved, you should find the defendant Nya Thao guilty. If you're not so satisfied, you must find that Nya Thao is not guilty. Reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes that every person charged with the commission of offense to be innocent. This presumption requires a finding of not guilty unless your deliberations you find is overcome by evidence which satisfies you beyond a reasonable doubt that Nya Thao is guilty. State's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Nya Thao is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with Nya Tao's innocence, you must do so and return a verdict of not guilty. Mean of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. Is it a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence? It means such a doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Nya Thao the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Nya Thao the benefit of any reasonable doubt that remains after carefully considering all the evidence. And the information is more than a written formal accusation against Nya Thao charging the commission of one or more criminal acts. You are not to consider it as evidence against Nya Thao in any way. It does not raise any inference of guilt. There is evidence in the case which, if believed, indicates that more than one person was involved in the commission of the offense. The fact that another person and other persons are not on trial is not material. You are to determine only whether Nya Thao is guilty or not guilty. Evidence is, first, the sworn testimony of witnesses both on direct and cross-examination, regardless of who calls the witness. Second, the exhibits the court has received, whether or not the exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly or by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Nya Thao committed the offense before you may find Nya Thao guilty. The court has taken judicial notice of certain facts, and you are directed to accept the following as true. Ken Fenerath Ratanasek entered a guilty plea on October 30th, 2023 to one count of first-degree intentional homicide as a party to a crime in a companion case. Evidence has presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made of the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement along with other evidence in determining how much weight, if any, the statement deserves. Evidence presented. Evidence has been presented regarding other conduct of Nya Thao for which the defendant is not on trial. If you find this conduct did occur, you should consider it only on the issues of context or background. You may not consider this evidence to conclude that Nya Thao has a certain character or a certain character trait that the defendant acted in conformity with that trait or character with respect to the offense charged in this case. The evidence was received on the issue of context or background, that is, to provide a more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves. It is not to be used to conclude that Nya Thao is a bad person and for that reason is guilty of the offense charged. Remarks of the attorney are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witness and the weight of the evidence. Disregard entirely any question the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or several other witnesses. In weighing the evidence, you may take into account matters of your own common knowledge and your observations, experience, and affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of your witnesses and determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses, and to the weight to be given to their testimony. If in your determination of credibility, you must avoid bias, conscious or unconscious based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matter the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all of the facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. A defendant in a criminal case has the absolute constitutional right not to testify. Nya Thao's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. Evidence has been received that some witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Consider carefully the closing arguments of the attorneys. But their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. With that, the court's going to break here, and we'll start with closing arguments. State ready with a closing argument?
Yes, Your Honor.
All right, go ahead and proceed.
With that, may I please have from the clerk Exhibits 112, 113, and 114? If I could have the screen, please. Nemo Yang, Hang Lore, Trevor Maloney. Young men in their early 20s hauled out to an empty quarry in the middle of nowhere, in the middle of the night, forced onto their knees, made to crawl out to a gate to look out into the darkness. Their hands behind their head, and executed one by one by one. Over money, over loyalty. Who all is responsible? Who all is culpable? Who all is concerned in the commission of this horrific crime? Ladies and gentlemen, the evidence that you've heard and seen throughout this trial makes it very clear that there were two men, two friends, two associates, two brothers, Mr. Camptoneth Ratnasak and Mr. Nya Thao, the defendant. These two men are responsible, are culpable, were concerned in the commission of the crime. They worked together and in concert to find and capture their prey and take them out in the middle of nowhere in the dead of night, to execute them and leave them for dead and flee off into the night across the state. Now, ladies and gentlemen, I say very specifically concerned in the commission of the crime of these clearly intentional homicides, because that is the law of this case. And Judge Levine just read it to you. I saw you flipping through and reading it along. That is the crime that Mr. Thao is charged with. That is the crime that it is the state's, it is my burden, it is Ms. Rood's burden to prove to you beyond a reasonable doubt. Party to a crime. Whoever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although that person did not directly commit it. There are three ways in which Mr. Thao can be a party to a crime: by directly committing it, by intentionally aiding and abetting the person who directly committed it, or by being a member of a conspiracy to commit the crime. The defendant intentionally aided and abetted the commission of these three homicides, then he is guilty of the crime as well as the person who directly committed it. If he was a member of a conspiracy to commit these three homicides, and these three homicides were committed by any member of the conspiracy, then he and all members of the conspiracy are guilty of those three homicides. I read these words to you because they are the most important. These are the crimes. These are what we're here for. And I would like to make clear, as the judge read to you, that you do not all need to agree on one of these three ways to find that Mr. Thao was concerned in the commission of these horrific homicides. All 12 jurors do not have to agree whether the defendant directly committed, intentionally aided and abetted, or was a member of a conspiracy to commit the crime. However, each juror, each of you, must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the 3 homicides in one of those 3 ways. Ladies and gentlemen, with these 3 ways to be concerned in the commission of the crime, I think of this like a pyramid a little bit. The layers add up, they stack up, and they provide support for each other as you go. And so with that, I'd like to start at the bottom of the pyramid and discuss what evidence proves that the defendant, Mr. Thao, was a member of a conspiracy to kill Nemo Yang, Hang Lure, and Trevor Maloney. A member of a conspiracy. A person is a member of a conspiracy if, with intent that a crime be committed, the person agrees with or joins with another for the purpose of committing that crime. A conspiracy is a mutual understanding to accomplish some common objective or work together for a common criminal purpose. It is not necessary that the conspirators had any express or formal agreement, or that they had a meeting, or that they all knew each other, although it's abundantly clear in this case. Black and Cush most certainly knew each other. If a person is a member of a conspiracy to commit a crime and that crime was committed by any member of the conspiracy, then that person and all members of the conspiracy are guilty of that crime. Mutual understanding, common objective, work together. 3 operative phrases in this definition. Ladies and gentlemen, when people come together with a mutual understanding, with a common objective, and they work together towards that objective, and they do it on, for example, a football field, we call it a team. When they do it working together at a rock quarry in the middle of nowhere, in the dead of night, and 3 people get executed, we call it a conspiracy. It's a crime team, if you will. So then let's look at the evidence of Mr. Ratanasak and Mr. Thao's teamwork, their mutual understanding, their common objective, their working together. First, we see that they worked together to get the boys to the quarry in the first place. You heard at length last week about the various steps that Black and Mr. Thao took at the Holiday Inn. Black, Mr. Ratanasak ordering Bridget Schlicht to follow him at gunpoint. And then the defendant, Mr. Thao, getting in Bridget Schlicht's car, getting right behind where she was going to be sitting in the driver's seat. Sitting behind her, where she can't see him, where he can see her, where she is totally and completely vulnerable to him. And she told you she was scared of him, sitting behind her. She didn't know if he had a gun or not. It's clear from the evidence there was only one gun, the .40 caliber, but she doesn't know that. She's sitting there in that driver's seat, no idea what's behind her, just somebody, Mr. Thao, who she knew, giving directions. And then on that drive, what was he doing? He was ordering her where to go, telling her where to go. Where did they go? Well, they went along 16, turned on M, go up to the quarry. We heard about It's remote. There's not a lot around there. It's the middle of nowhere. And in fact, it's out in the middle of nowhere such that Black, Mr. Ratanasak, he didn't exactly know how to get there. He wasn't from the area. We heard that. Mr. Thao was from the area. He was from La Crosse. Black was not. He was the newcomer. And that's why at one point during the drive, there's the phone call that Bridget overhears between the defendant and his brother Black, where Black says, let's switch places. Those aren't the exact words. I'm paraphrasing. You go in front. Now, we had heard that Ms. Schlicht had been to Nemo's mom's house up by that bump out on M, but that's 2 or so miles, about 2 miles from the quarry. Quite a distance, 2 miles. That's as far up M as she had ever been that she'd gotten before, and she told you that. But Mr. Thao knows, and he gives the directions, and he leads her there. He's providing directions to the quarry. Why am I emphasizing this? This seems, why there's so much other interesting evidence in this case. Why are you talking about giving directions in a car? Interesting that out of all of the testimony we heard about that awful, scary car ride out to the quarry, and the phone calls going on, the back and forth, all the Facebook phone calls, you never heard, not one time, that Black said to Mr. Thao on the phone or to Bridget or anyone, hey, we're going to the quarry. You didn't hear in any of those phone calls, any of those conversations, the word quarry exchanged. Why is that important? What does that tell us? It tells us that that was the mutual understanding. Mr. Thao already knew where to go. Bridget Schlicht didn't pick this place. So even if you followed that line of defense questions insinuating that she knew how to get to the quarry, there's no evidence, none whatsoever, that she was given some kind of free rein to choose this location or that she was ever even told the final destination. Which leaves you with 2 options, both of which go to their conspiracy. First, that Black chose it and told Mr. Thao ahead of time, and then somehow forgot the directions, didn't remember them, wasn't familiar, easy enough to slip your mind, needed him to go ahead, get in front, I forgot how to get there. Or number 2, that Mr. Thao chose it. That Mr. Thao chose the remote location in the middle of nowhere, in the dead of night, in the area that he was from, in the La Crosse area. Black's not from the area, he is. Either way, that shows you that there was a plan between Black and Mr. Thao. No one ever had to say out loud what that plan was, where they were going. And as we think about this plan between the 2 men responsible, I want to discuss the plan to kill and the defendant's clear knowledge of that plan. I want to talk about the Facebook messages, the Facebook phone calls. Let's talk about the Facebook messages and the Facebook phone calls from Mr. Thao's account. One of the things we've learned through this trial was that the motive behind all of this was some kind of debt. Nemo stole money. Everybody's looking for Nemo. Nemo ripped us off. Michael Vang, Bam Bam, told you in his own way that Nemo was suspected, accused of stealing this money. And Mr. Vang, having known Nemo his whole life, practically, babysat him growing up, he offered to pay it. He'd come into money, said, I'll pay the debt. And that's when someone said to him, I don't want your money, I want his life. Probably didn't use it in the nice tone of voice I used. I don't want your money, I want his life. There's a lot to unpack there. First of all, that statement came from a voice speaking through Mr. Thao's Facebook account. Now, Mr. Vang couldn't say on the witness stand whose voice it was, whether it was Black's or whether it was Mr. Thao's. He has said previously, he said at the time it was Black's. He can't say that now. Let's go with what he said before. Sure. But we know that that voice came through the defendant's account. What does that mean? What does that mean? Anybody who's ever used a Facebook account, made a call through Facebook Messenger. So we know from this, we have Mr. Thao allowing his friend, his brother, his teammate, if you will, to use his Facebook account. He's allowing him to use that, to make threats like this. How would Black have been able to call through the defendant's account? The defendant would have opened up his account, handed over his phone, and now I say his phone, it's not reasonable. We have no reason to think. It is not a reasonable hypothesis that they're working some sort of laptop. We heard nothing about a laptop, or that they're at somebody's place with a desktop trying to do some sort of call through that. It's a Facebook app through the phone. We heard through Investigator Amundsen that it was associated with the defendant's phone number. It's an app on his phone. And so to use his account, to have Black use his account, he opens it up, hands it over. And so the defendant would have been, at the very least at that time, on notice that this situation was incredibly serious. I want his life. Is it really so outlandish to believe people when they tell us something like this? Is it really so outlandish to think that when someone says, I don't want your money, I want his life, that perhaps they don't want your money, they want his life? Is it so outlandish to mean what you say and say what you mean? At that point, at the very least, the defendant was on notice. He knew this was serious, this was going someplace. Well, what other Facebook evidence is there that Mr. Thao and Black went to the quarry with a plan, with a mutual understanding, a common criminal objective, working together to kill the boys? We have the messages. These messages, what they show, we'll read through them, is that the defendant, Mr. Thao, is the collections department for Mr. Ratanasak. He's Black's collections department. This is exactly like what happens when debt goes unpaid and it goes to collections and collections starts calling. Hey, you need to get that 80 to my big bro when he gets better today. You hear me? He's coming to collect only. Real talk. Real talk, Nemo. He ain't playing games. Mr. Thao, collecting. And the day goes by, and he gets more upset because he's not getting paid. Black's not getting his money. Games, games, hours gone. You're too late. I told you already. When are you going to get the money? Because he tripped, say me. He's upset. He's mad. Time to pay up. Let's go. Collections. Bro, we need to see like 60 to 80. It's July 20th now. Still going. Nemo owes money. Pay up now. Black's getting mad. Mr. Thao is doing Black's dirty work. We go on, and there are messages to other people now about the growing tension, the growing need for Nemo Yang to pay up. July 21, the Thai BWJ. It's all online shit. I can guarantee half the money till my bro Black is here and give me the other. The significance of this, ladies and gentlemen, and why this shows Mr. Thao is doing the dirty work. He's doing the collections. He and Black are a team. They're a conspiracy. They're sharing money. The money, Black's money, flows through Mr. Thao. It flows back and forth. I can guarantee half, so my bro Black is here. There isn't his money. It's flowing through each other. It's their money. A debt to one is a debt to both. And even further, it would appear, in addition to just Black having money taken by Nemo, now in July 16th, 17th, Mr. Thao is starting to suspect, he's starting to accuse Nemo Yang of also stealing money from him. This is personal debt to him. Have you seen my debt card? Debit card, debt card? Looking for it. It's my mission. I'm missing all my money. It's all I have. I'm bummed about it. Nemo had to have taken it. Black's mad. Nemo owes him money. The defendant is mad. Nemo took his money. Been going on for days now. Games, games, hours gone. Your time is running out. Call, 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 call. Have it your way, LMFAO, laughing my effing ass off. Tell Nemo, since he won't show himself, I'm going for his family. Time's up. I know his family. I could not be more serious. I'm looking for Nemo. Nemo owes us money. We're done here. July 18th through 19th. Just a few days before Nemo Yang pays for that debt. Nemo Yang pays for that debt with his life. And now it's at this time, these few days before the shooting, that Black, Mr. Ratanasak, and the defendant start looking for Nemo. It's about the 20th, 21st of that week, Tuesday, Wednesday-ish, when Michael Luco sees the defendant, sees specifically Mr. Thao, who he's known at that time for 15 or so years. He sees Mr. Thao along with his brother Black at a house, and the defendant is looking for Nemo. He's got a .40 caliber Glock in his waistband, and it's an interesting, it's a significant, it's a salient piece of evidence there. Mr. Luco sees a .40 caliber Glock in his waistband. He knew that, .40 caliber Glock. interest to me that for all of Michael Luco's baggage, and he's got a lot, absolutely, that years, over a year, almost 2 years, before that .40 caliber Glock was found by Seth Barna picking up trash along the side of the road, collected by Deputy Ratkovich, and confirmed by Jessica Crawford. Years before that, over a year, almost 2 years, Mr. Luco knows a .40 caliber Glock. And it's important that he says that. He says, I saw it in his waistband. And what did he tell you? How did he know? He said, well, it's written right on the side of the barrel. And before it was ever found, look at that there. What's written right on the side of the barrel? Glock, 40. Also in those days, the 20th, 21st, Tuesday, Wednesday before the shootings, Flora Johnson sees Mr. Ratanasak and his brother, the defendant, at the wharf. And they're looking for Nemo. The defendant is looking for Nemo. And the defendant has a gun in his waistband. Bro and Black. Bro, brother, and the defendant looking for Nemo. And at that time specifically, it's the defendant flashing a gun. They've got a gun. They're showing a gun, looking for Nemo. I want his life. That's what guns do. And then it gets to be the 22nd, gets to be Thursday, and the defendant, Mr. Thao, is the one talking with Mr. Vang, Bam Bam, working to round everybody up, doing Black's dirty work. July 22nd, between the defendant and Michael Vang. Some of us talk, you can have them. Who them? I know, because he a snitch. Interesting, he says, because he a snitch. What did we learn was the quickest, easiest way to make yourself a target for physical violence? Him and his guy. Who is guy? The little guy with him. Where? Dude, when you call about that, they made them leave, bro. Made him leave the hotel. Let's talk. On my way, what room? Mr. Tao's trying to find out. What room? What room? Where are you? Where are they? Let's talk. Let's meet in person. Mr. Vang does not want to meet in person. They ain't here. We don't want to do anything to do with them. I got my own drama. I don't want to be a part of your drama, Mr. Vang said. Don't want to be a part of this. You can have them. Be done. Still looking for the room number. Have to chase this bitch down. Supposed to have been with Nemo. Mr. Vang uses a Hmong phrase. That's significant because he used Hmong at times to speak with the defendant. Not Black. Hang here with both. Call and no answer. Now, we had testimony from Mr. Vang from Bam Bam, sort of saying that he thought maybe this was going to be a beatdown. If he thought it was going to be a shooting, might have done something different. Well, it's significant on that point, ladies and gentlemen. What do we hear? They're not in a room together. Mr. Thao wants to meet up. Mr. Vang does it. They're not in a room together. They're not together. That's important because Mr. Vang didn't see the Glock. Bam Bam didn't know a gun was involved at that point. Could he have suspected? I don't know, but he didn't say that he saw one. He didn't say that he knew one was involved. He did not testify about that. Perhaps if Mr. Vang had met up and seen the .40 caliber Glock, he'd have thought otherwise. Now on that point, let's take a moment and look at a few other reasons why this maybe Mr. Thao thought it was just going to be a beatdown theory that's been hinted at, is not reasonable, does not reconcile with the evidence. A gun has been flashed. A gun is involved at that point. And once again, a dark, empty quarry in the middle of nowhere, in the dead of night. It's dark, and there's no one there but those 6 people. Now, counsel back last Monday made reference to a saying, if you don't want to slip, don't go to slippery places. Ladies and gentlemen, it does not get more slippery than an empty quarry at 2:30 in the morning with no one around. It's so slippery, it's practically a slip and slide. Ladies and gentlemen, this situation reminds me, there's a pretty famous movie that's got the tagline, "In space, no one can hear you scream." Well, ladies and gentlemen, at a rock quarry, in the middle of nowhere, in the middle of the night, no one can hear 10 gunshots. Let us think about Bridget for a moment. Bridget Schlicht, who testified, she said, I thought maybe they'd just get beat up. Bridget Schlicht, ladies and gentlemen, is the poster child for shock and denial about what was going on, what happened, all along through her experience. So much so is her shock and denial about this whole situation that even after it happens, and even after she's terrified, and even after she gets back, she's driving back to the Holiday Inn, she calls Trevor Maloney's phone. She saw Trevor Maloney get shot in the temple, drop to the ground, and she called his phone. Why'd she call his phone? That's denial. What did she tell you? I was hoping he would answer. Hope against hope, praying that what she'd just seen, this horrific action, wasn't actually true. Hadn't actually happened. Trevor didn't pick up. Trevor never picked up again. Trevor was laying on the ground at the quarry, not answering his phone. That's denial. Let us also not forget something interesting about Bridget. Bridget told you about having a black eye and about getting jumped at a Quick Trip in the days prior. With that, ladies and gentlemen, you get a taste for how a beatdown actually goes down. Punch, it's a black eye at a Quick Trip within city limits. What'd Bridget do? She took her licks. She moved on. That's a beatdown. That's not being in a quarry in the middle of the night, getting executed by a gate. And then lastly, I ask you all to remember Trevor. Trevor sitting in the back passenger seat of Bridget's car, riding out to his death. What did Trevor say? He told Mr. Thao about his 2 beautiful girls. Sitting in that car, tells the defendant, I have 2 beautiful daughters. Ladies and gentlemen, you don't tell someone about your two beautiful children waiting for you at home because you think you're going to get beat up. You don't tell someone about your two beautiful daughters because of a beatdown. You tell someone sitting behind the driver, breathing down her neck, about your two beautiful daughters because you want them to know that you have something to live for, that there are children who are going to be affected by what's about to happen. There are children who are going to have no father if you do what Trevor knew in the pit of his stomach was going to happen. You say that because you don't want to never see them again. Trevor Maloney knew exactly what was going to happen. And so did Mr. Thao, sitting right next to him. Ladies and gentlemen, Mr. Thao and his brother Black joined together for their common criminal objective of taking the boys out to the quarry to never come back. Let me just say this. I think it's clear when I talk about taking the boys to their death through the evidence that Mr. Ratanasak and the defendant's true target was Nemo, but Pang Lore, his guy, the little guy with him, gets included with Nemo. And then Trevor Maloney, just hanging around and smoking meth, gets swept up in it too when he lies about who he's with on the phone and where they are. So by the time that they're all driving to the quarry, the targets have now become all three young men. Let us put conspiracy aside and turn to aiding and abetting. A person intentionally aids and abets the commission of a crime when acting with knowledge or belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist. And the person who commits the crime knows of the willingness to assist. To intentionally aid and abet first-degree intentional homicide, the defendant, Mr. Thao, must know that another person is committing or intends to commit the crime of first-degree intentional homicide and have the purpose to assist the commission of that crime. However, a person does not aid and abet if he is only a bystander or spectator and does nothing to assist the commission of a crime. First, ladies and gentlemen, the evidence that I've gone through, the evidence that the defendant knowingly assisted with these homicides is the same as what I've gone through. It's the same as the conspiracy. That's our pyramid. Being a member of the conspiracy and doing the actions I've gone through, that's assisting, that's providing assistance, that's being ready and willing to assist. I've already gone through that. So let's look at what additional evidence there is that goes towards aiding and abetting. How he assisted at the quarry, and how the defendant knowingly was ready and willing to assist. With that, let's talk about shoe prints for a moment. We see here from one of Nick Stalky's photographs, we have the shoe prints. We have the two voids where the two cars were consistent with what Bridget told you. Bridget's car at the top, Mr. Ratanasak's on the bottom. We had those closer shoe print markers, 23, 24, 25. Mr. Stalky told you about those being the waffle print. And the majority of what was in between being the chevrons. And especially I find it interesting, marker number 8. We're at a different angle when we look at this one. hard to see. It's in the most back. All the way up at the top. 8 is a chevron. Mr. Stalky told you 8 was a chevron. What this is consistent with is Bridget's car pulling in and that number 8 chevron, the seat behind the driver's seat, getting out, coming around the back, 9, 10, 11, chevron, 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 and going between the cars. Many chevrons. Mr. Thao's chevrons. And then consistent with the car backing in and the driver being closest to us, getting out consistent with the waffle impressions. And then we have this image when we think about shoe prints. Mr. Panglore's foot, his shoe, and then what is all around him? Prints upon prints upon prints upon prints. There are waffle prints. There are chevrons. Many, many, many chevrons. Chevrons kicking Nemo in the chest, which is corroborated, I would note, by Dr. Reichert's autopsy finding that Nemo Yang had abrasions on his chest. Chevrons pacing back and forth. Chevrons emptying out pockets. Chevrons turning over Mr. Lore's body. Chevrons assisting the homicide. At some point, ladies and gentlemen, here at the quarry, any thought, any hope that this was just a beatdown had to have been utterly wiped away and replaced with clear knowledge and clear understanding of exactly what was happening. When those boys were put on their knees, ordered onto their knees, made to crawl out, get up against the gate, put their hands behind their head, turn out your pockets. Those are the actions of an execution. That's not a beatdown. And that was all happening right in front of Mr. Thao. And then pacing, assisting, turning pockets out. After they're dead, turning Panglore over. This is so significant, ladies and gentlemen, because how these bodies are lined up, how they were shot in the back of the head, shows you that that's exactly how this was set up, how this was arranged, how these men, how Black ordered them up against the gate. It was happening right in front of Mr. Thao's eyes, exactly in the manner Bridget described. It was set up exactly like an execution. And that tells you, ladies and gentlemen, that this did not happen all in a hurry, out of the blue, spontaneous, all of a sudden bullets flying. Oh no, they were placed there. Which means anybody there, anybody observing that, saw it and would have known exactly what was now going on. Bridget knew exactly what was going on. That's why it's important that when Black said, shut up or get on your knees and join them, Bridget shut up, didn't join them. Didn't want to get shot. She didn't want to be put up against a gate, execution style. She knew exactly what was going on. And so too did Mr. Thao. This is why, ladies and gentlemen, once Mr. Thao saw them getting lined up, he knew exactly what was going to happen. And that's the significance of him then assisting at that time, emptying the pockets, turning Mr. Allure's body over. And those actions prove beyond a reasonable doubt that he was ready and willing to assist Black. And Black would have seen and known of that willingness to assist. The next evidence, ladies and gentlemen, that proves aiding and abetting beyond a reasonable doubt, and in fact, in many ways, is some of the strongest and clearest signs that Mr. Thao acted at the quarry with knowledge, with intent, and belief that he was aiding and abetting 3 intentional homicides, is all of his actions after the fact. We call that consciousness of guilt. You heard the judge use that phrase when he read the jury instructions to you, consciousness of guilt. And I want to point you specifically to this instruction that says evidence has been presented relating to the defendant's conduct after the alleged crime was committed, whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. These are the things one does, the things you do because you know how very, very guilty you are. So much so, there's an entire jury instruction about it. This evidence of consciousness of guilt, that after these 3 young men were dead, alone, in the middle of nowhere, in the middle of the night, we know that Mr. Thao got into Black's car, got into his Mercedes-Benz, titled in Ms. Kryle's name, and the 2 of them just drove away. And they drove through the night, in the early morning, out all the way to Algoma, over 200 miles northeast, driving together in the night out to Algoma. Before they got very far, they dumped the gun, started getting rid of evidence. They dumped this gun here, this .40 caliber Glock, the one found by Mr. Barna, collected by Deputy Ratkovich, confirmed by Jessica Crawford to be the gun that shot the bullets, the fired cartridge cases on the scene that killed the 3 boys. It was found in this location by Mr. Barna. And as we look at this location, let me point out, it's a little, gun is right here. On the other side of the makeshift guardrail on the shoulder of the road. That gun located N 7305 County Road M, Holman, Wisconsin, on M. What was described to you was that as we're looking at this photograph, we're facing northeast. We're facing northeast as the car is driving northeast on M. And that gun is on the passenger side of the road. Why is that important, that it's on the passenger side of the road? Well, who's the passenger in the car? Nya Thao is the passenger in the car. Nya Thao threw the gun out the window. It is not reasonable, ladies and gentlemen, whatsoever to think Mr. Ratanasak was not driving the car he was, I guess, borrowing, using, given to him by Ms. Kryle. It is not reasonable whatsoever to think that on this drive away from the scene, Black's driving and sort of says, hey, Mr. Thao, why don't you lean back? Driving, opens the passenger window, throws the gun out on top of Mr. Thao. Mr. Thao dumped that gun. That's what these show you. Dumping that gun shows you Mr. Thao has consciousness of guilt. Mr. Thao is willing to assist with a crime. Mr. Thao is totally okay at this point with what he's assisted with what has happened. He's okay getting rid of the evidence. That's consciousness of guilt. That is not all of the consciousness of guilt. Mr. Thao is also in Algoma. He's at Mr. Ratanasak's girlfriend's house. A little unclear what exactly their relationship is. We'll say girlfriend. In the morning during the day of July 23rd, Ms. Todd Weckler told you there's this other guy kind of hiding back in the shadows. Mr. Weckler can't identify him. But Mr. Tao's mail can. Mr. Tao's cardholder services mail identifies him. There in Algoma and Virginia Cryle's garage, garbage, along with Lacrosse Quick Trip receipts and the Family Dollar in Muscadet. Nya Thao's mail. And not insignificant mail. We have made a final determination regarding the claim referenced above. He's supposed to be getting money because he's missing money. Money is important to Nya Thao. It's important to everyone. I would also note when we look at this mail, it would appear Nya Thao was not homeless, at least not June 30th of 2021. Nya Thao has an address on Flint Street in Onalaska. What else is Nya Thao a part of in Algoma? What do they do in Algoma? They get rid of bags of evidence. Holsters, bullets, clothes. Dumping more evidence, more consciousness of guilt. Then after dumping the Mercedes-Benz in the Green Bay area, Mr. Thao finds himself in Wausau, a place he was not from. Finds himself in this house in Wausau a couple days later wearing a long black wig, a baseball cap, and writing in his journal. When he wrote in the journal, we don't know. But he's got a journal in his backpack. He's been writing in it. What does Nya Thao write in his journal? A journal, a place you put your innermost thoughts, perhaps. What does he write in his journal? Does he write, "Dear Diary, I cannot believe the horrific thing I just saw. I thought we were just going to beat these guys up, but instead, my brother Black shot them. How will I ever deal with this trauma?" Does he write anything like that? No. Nya Thao starts brainstorming ways to call Bridget Schlicht a liar. Notes on Bridget's motive. Dislikes me. Nosy in her own way. Nosy in her way. Of what? What'd I do that led her to target? Things/actions. Her. Don't indulge in her. Silent treatment. Never gets what she wants. I stand in her way of getting plugged. Why me? Easy target, slow and stupid, illiterate, don't know how to explain points and views, blunt and words mean different things. Counsel did his best when we talked about the journal to make it seem like somehow these are, I guess, Nya Thao's earnest notes anticipating being thrown under the bus by Ms. Schlicht. why would Mr. Thao be in a position, why would he think he was being targeted by Ms. Schlicht? How would he have any idea what Ms. Schlicht said to police? Why would he have any idea that Ms. Schlicht even went to police? Let's remember, where did Nya Thao and Bridget Schlicht leave things? A 9-minute phone call that she had initiated. As counsel insinuated, trauma bonding over that phone call. What did he say? Bridget, you're a good friend. Is that somebody you need to start writing down notes on Bridget's motive? And let's also notice there was a lot of questions about this. Slow and stupid, illiterate. We had a lot of questions about proper punctuation and the use of an exclamation point or a question mark. I would put to you, ladies and gentlemen, let's consider instead the oxymoron it would be to call yourself illiterate by correctly spelling the word illiterate. And doing so in perfect, beautiful, cursive penmanship. Not a single word is misspelled. Is Mr. Thao the one that he's saying, oh, I'm illiterate, I'm slow and stupid? Mr. Thao is getting ready to call Ms. Schlitt slow and stupid, illiterate, from Vernon County, meth addict. She's the easy target. You know what, ladies and gentlemen? There's the journal. You saw it. You've seen it twice now. You all read this. Draw your own conclusions. You heard the testimony. You know what words mean, why people write them down, why people do what they do and when. You, ladies and gentlemen, know what these journal entries are exactly about. It's consciousness of guilt. And the last part on aiding and abetting I have to comment on is the bystander or spectator portion. It's true, a person does not aid and abet if he is only a bystander or spectator and does nothing to assist the commission of a crime. Ladies and gentlemen, that line is for people who do something like go to the Quick Trip, intending just to get some chicken tenders. They're Midwest nice. They see somebody behind them. They open the door. They say, have a nice day. See you again next time. Something like that. And unknowingly, they've let the armed robber into the Quick Trip. That's a bystander. That's a spectator. That line is for people like Bridget Schlicht, who inadvertently, unknowingly, naively, drove 3 men to their deaths. And then ultimately went to the police, handed over her phone, let them search her car, sat with them for 11 hours, needed a safe house. That's a bystander. That's a spectator. It's not for the person who was at the quarry pacing back and forth, taking things out of men's pockets, and then dumping guns on the side of the road. That's not a bystander. That's not a spectator. That's an active participant. And with that, ladies and gentlemen, we turn to the final way in which Mr. Thao can be concerned in the commission of the 3 intentional homicides of Nemo Yang, of Pang Lor, and Trevor Maloney. And that's by directly committing it himself. And that's exactly what Bridget Schlicht told you he saw him do. That's what Michael Luco said, told you, the defendant said he did. That Black handed him the gun, that Mr. Thao paced back and forth, and then ultimately said, F it, and pulled the trigger at least 10 times, putting 3 4 bullet holes in each young man. I'll address Mr. Luco first. Let's call it what it is. The state hides not at all what Mr. Luco is. He's a jailhouse snitch, right? Absolutely. And he comes with baggage. He comes with a lot of baggage. Bags upon bags of baggage. He's a criminal. He's a drug addict. But he's clean and sober now. He's a graduate of drug treatment court. He's employed. Some things that I put to you make him credible, that is believable in his statements to you. He's known the defendant at this point now for about 18 years, knew him for 15 years at the time this happened, and he saw him just a few days before the shooting, before the homicides. Isn't that exactly, ladies and gentlemen, the person you see in jail, scared about the trouble you're in, anxious, worried, and upset? Isn't that exactly the person you speak to? Ladies and gentlemen, you don't speak to Boy Scouts and Girl Scouts and upstanding members of the community about having committed a triple homicide. You talk to people you know, you trust, who have their own baggage. You talk to people who have face tattoos. You talk to people who have 10 criminal convictions. You talk to people who have been in and out of jail for, 20 years? Who you talk to? How did Mr. Luco know details? Like that they were on their knees? Or that Black Pistol whipped Trevor Maloney? Or that Trevor was shot last? Are we to think Michael Luco, the man with the face tattoos, is reading criminal complaints and committing them to memory? Or that he's memorizing a story given to him by Black? Ladies and gentlemen, Mr. Luco needed a Post-it to tell him how many criminal convictions he had. This is not a man memorizing criminal complaints and going through discovery that hadn't even been given out at that point. Mr. Luco put himself in danger by snitching. Snitching, easiest, quickest way to make yourself a target in jail. He did not do that to protect himself. There's no evidence that he did that to protect himself, to get any kind of protection from anyone. That's not how snitching works. That's not inmate currency. Inmate currency is ramen noodles and honey buns from Canteen. And then there's Mr. Luco's knowledge, a year and a half, 2 years before it was found, about the specifics of the gun. He knew it because he saw it. He reported it, Mr. Leinfelder, in August of 2021, and it wasn't even found until April of 23. Ladies and gentlemen, I get it. He's a jailhouse snitch, but his information checks out. It's corroborated by Dr. Reichert, by Nick Stalkey, by Seth Barna, by Cody Ratkovich, by Jessica Crawford. And then, ladies and gentlemen, that leaves us with Bridget Schlicht. What is there to say about Bridget Schlicht that wasn't already said or made abundantly clear when she testified? Bridget, too, has baggage. Bridget Schlicht is a Vernon County girl with a meth problem who got in way over her head. Started off hanging around in hotel rooms and smoking meth. Inappropriate behavior you don't have to condone. But that's who she was. Until that day when everything took a horrific turn and changed her life. I've gone through already so many things that corroborate her story. The final two are these. These many, many chevron prints all around the bodies. What did Bridget say? She said, Mr. Thao, the defendant, was handed the gun, and he was told, you better do this before I do it. And he takes it, and he paces. We have all those chevron prints pacing back and forth. And there's that statement, you better do this before I do it. That, ladies and gentlemen, is consistent with those Facebook messages and the Facebook phone calls. And Mr. Vang and those other individuals, Shenoa Dawn, Nicole Wisniewski, messages between Mr. Thao and Nemo Yang. What does Mr. Thao do? He does Black's dirty work. Black tells him to collect, he collects. Black tells him about the friendly warnings, I think they were. Mr. Thao gives the warnings. Black tells him to shoot 3 people, and Mr. Thao does it. And the final piece, ladies and gentlemen, the final piece, that Nya Thao let Bridget Schlicht live. Mr. Thao was the nice one. You're a good friend, Bridget. Black was the mean one. If Campaneth Ratnasak had that gun in his hand, there is no way he would let her live. Black had already gotten sex from her, spending that day calling, talking on the phone over an hour, many phone calls. Talked to her, made her feel special, buttered her up, had sex with her, didn't call her again. He had no more use for her. Crass, gross, ugly. He was done with her. There is no way Black, holding that gun, was going to let Bridget Schlicht walk away from that place. He would have absolutely killed her, leaving no witnesses. Ladies and gentlemen, Mr. Nya Thao shot that gun he was prohibited from even possessing. The defendant, Nya Thao, executed Nemo Yang, Hangmore, and Trevor Maloney. The defendant, Nya Thao, is guilty of all 4 counts. Ladies and gentlemen, deliver the verdicts that the evidence demands and justice deserves, and find the defendant guilty. Thank you very much.
Thank you. I think we're going to just take about a 10, 15, well, let's do a 15-minute break. We'll aim for 10. So again, please don't talk about the case. We're still in the middle of the last part here, and we will see you back, let's say 25 to.